So I'll invite them to come forward and the committee will just move on to the Australian Communications and Media Authority, the Office of the E-Safety Commissioner and the Department of Infrastructure, Transport, Regional Development, Communications and Arts.
Yes, thank you. Thank you very much.
Okay, the committee now welcomes representatives of the Department of Infrastructure, Transport, Regional Development, Communications and the Arts, the ACMA and the E-Safety Commissioner. For the Hansard record, could you please state your name and the capacity which you appear today?
Richard Windia, Deputy Secretary, Media and Communications in the Department of Infrastructure, Transport, Regional Development, Communications and the Arts.
Andrew Owen, Acting Assistant Secretary, Platforms and News Branch within the department.
Nerita O'Loughlin, Chair, Australian Communications and Media Authority.
Cathy Rainsford, General Manager, Content and Consumer Division, Australian Communications and Media Authority.
Toby Dagg, Acting E-Safety Commissioner.
Thank you very much for your attendance and assistance with the committee today with our inquiry. Does anyone wish to make an opening statement?
Thanks, Chair.
Great. Okay, we'll jump straight into questioning and I'll lead off and then I'll have to call to my colleagues. I want to start with the Combating Misinformation and Disinformation Bill, which has attracted some attention in the media in recent days and the views of some witnesses before the committee. And this would have started at kind of a principles level on first the department and then, if it's any different, the ACMA's view on what constitutes disinformation and misinformation and how the two of those things differ from each other, if at all.
Chair, I'm happy to start. I mean, I think from the department's perspective, the answer to that question goes to, in a sense, the way they are defined or the definition set out in the Act. There are sort of four elements to misinformation, and the same four plus a fifth, which brings in intent, is relevant to the definition of disinformation. To help answer the question, just to reference what the bill says, misinformation on a digital content using a digital service is misinformation on the digital service if the content contains information that is false, misleading or deceptive, and the content is not excluded content, and the content is provided on the digital service to one or more end users in Australia, and the provision of the content on the digital service is reasonably likely to cause or contribute to serious harm. And then disinformation is the same elements, with the addition that the person disseminating or causing the dissemination of the content intends the content to deceive another person.
So the definition in the proposed Act of misinformation would also capture people who are innocently sharing false information that they do not know is false.
Certainly misinformation captures material that is not intended to cause harm. And yes, I mean, I suppose the answer to your question, Senator, I think that is right.
I think I'd clarify, though, there, Senator, that it's not about capturing people; it's about capturing content on platforms.
Sure, but I think that the motivation of actors is relevant here because it is not unlawful to be wrong on the internet. People and a lot of misinformation is people unintentionally being wrong, sharing things that they think are true but may not be true, and they don't have a malicious intent. But it does appear to be captured by this legislation, which is also aimed at much more concerning conduct, which is deliberately false information that people have a ulterior motive of putting into the marketplace of ideas. Shouldn't seeking to deal with shouldn't we be seeking to deal with these problems quite separately? Aren't they quite different and distinct problems? We don't go around fact-checking the individual content that people provide that is wrong on the internet, but we should be concerned with a foreign actor, for example, as this committee is, trying to harmfully propagate falsehoods.
I think, Chair, the way I'd respond to that is to say that I think what this bill is trying to do is tackle, to take a shorthand approach in a way, is to tackle content that is reasonably likely to cause or contribute to serious harm. So, and that, in a sense, is the intent of the bill, to catch, for digital platforms to take steps and responsibility for the content on their platform, and in doing so take steps to address content that they judge could be likely to cause serious harm. So the focus is on the harm and the content rather than the intent or the source of the content, if that makes sense.
But the effect of this still could be people innocently sharing content on these platforms which is unintentionally false being censored by the platforms as a result of this.
Well, only if that content causes serious harm.
Our understanding of what constitutes misinformation also changes over time. Things which are previously regarded by experts as constituting misinformation subsequently often turns out to not be the case. How can we be sure that this won't lead to further censorship of things which appear to be misinformation at one point but subsequently turn out to be truthful, or at least have arguable degrees of difference?
So I'll make a couple of comments. It may be that the ACMA has comments to make as well. I suppose the point I would make is there are, I think, understand and take that point that things change over time. A couple of things that are worth keeping in mind. Firstly, that the judgment of or the determination of dis and misinformation on a digital platform is a responsibility that is being quite intentionally left in the hands of the digital platforms to manage themselves. Second point to make is that what this bill envisages is that the digital platforms will have a whole lot of processes or measures in place to tackle misinformation, not all of which need to go towards removal of content. So to the extent there is content, therefore, might, if new information arises and the context of content changes, that may well be able to be addressed because the steps that the platforms choose to put in place to deal with the misinformation go to flagging or explanation or fact-checking or what have you. They don't necessarily it doesn't necessarily lead to all paths for a digital platform are to decide to remove content. The other point I would make is to allow us to understand at a systemic level, not at an individual content piece level, what's occurring over time. There are some quite important provisions in the bill which relate to the ability to gather information for the purposes of getting a sense of what is going on.
Yeah.
But I would important to remember that is not looking to gather information about sort of individual instances of content. But
Chair, I think I'd only add to that this is currently what the digital platforms are already grappling with. So the code was introduced it was requested in 2020 and introduced in 2021. And it really was to set in place a framework for the platforms themselves to identify content of concern or indeed inauthentic behaviour on their platforms. So to identify it, to assess it, and then to put in place, as Mr Windia said, measures to deal with that. So it was trying to seek a balance between minimising misinformation and disinformation on those platforms while upholding freedom of speech. So the platforms have already been grappling with some of these issues over the last few years, and I think that the matter that you've raised has been one of the things that's been quite tricky for them to deal with as information changes over time. I think where the platforms have adjusted their processes, being more open to engage where things may have engaged, dealing with complaints from people who may have had content not necessarily remove but deprioritise
Yes.
of engaging in that conversation as different facts emerge or different information emerges. But I'd say that that's what they're grappling with currently, and what the current bill doesn't change that. That still leaves digital platforms responsible for handling the content on their platforms.
Well, in the evidence they gave to us yesterday, it does change that in a material way because it attaches significant financial and potential, in the words of
Only if standards are put in place, which is not intended in the first instance. The first instance would be the current arrangements remain in place, and only if those arrangements are seen to be failing, and that's failing at a systems level and a process level, not an individual content level, then at that point, or indeed if there are platforms that have not signed up to that code, only at that point could the ACMA consider requesting a code which would be assessed by us.
I do understand that, but as the platforms themselves testified before the committee yesterday, they acknowledged that already, simply under the voluntary arrangements that are in place, they have not always got the balance right between free speech and misinformation and disinformation.
I think that's a challenge for them.
And they have censored, or to use your language, deprioritised or restricted the sharing of some information wrongly because of a caution in this area. And they said to us that with the addition of potential financial and criminal penalties under this scheme, that their sensitivity, their willingness or their desire to intervene earlier and be more restrictive on content is going to be heightened. That's a natural response for them, even if it's a consequence which is down the road, as you say, and it has to meet several tests, they're still going to be more sensitive to it. So if they're already censoring more content than they should in some instances under a voluntary code, aren't they going to do even more under this legislatively backed code?
Well, I think what Meta also said yesterday is that they wanted to engage. I mean, this is an exposure draft of the bill.
Yes.
I think most of the platforms yesterday, from my reading of their testimony, said that they were, one, quite comfortable with the current arrangements, although they realise that those need to be improved. Secondly, they saw some benefits in having a regulatory backstop for those arrangements, but that they wanted to engage through this exposure draft process, and obviously Meta raised these issues about the standard and their concerns about the penalties. So I think they're very valid concerns that they've raised. I'm not quite sure I understand their reasoning behind. I can see that they may self-censor. I'm not quite sure I see the reasoning behind their statement, but that's what they've said that they're thinking about and prepared to propose alternatives and submissions to the government over this exposure draft process.
Yes, but the only thing we do have that's available to us now to consider is the exposure draft. So I take your point, it could change, but what we have before us I think is what we need to consider because it does have significant implications for this issue of foreign interference through social media. That is a serious issue which we do need to address. It wasn't only Meta though. Twitter was quite concerned with this approach, and Google and YouTube were more comfortable, but so there's a range of opinions in the industry, and Twitter in particular articulated quite a philosophical objection to this way of dealing with this problem. Aren't there other ways of dealing with this problem, particularly as it relates to foreign interference? I mean, I take your point about coordinated inauthentic behaviour. No one wants to see that, and there's no free speech rights that are being restricted if bots are being removed from someone's platform. Shouldn't that be, or if the activity like that, behaviour like that, rather than the content of the material, be a better focus for this issue?
Senator, Chair, I think that has been the debate internationally around misinformation and disinformation on platforms. And it is now a combination of both that we're seeing internationally and domestically, that it's not sufficient, and as Mr Windier said, we're focused on serious harm, that there are measures that the platforms do put in place and have put in place that deal with inauthentic behaviours, but they also are more seeing in particular pieces of content that they have to deal with as well. So we think that the measures that they have in place already deal with both of those types of areas of concern, and we think that the current code, while we have some concerns with some parts of it in terms of transparency and accountability, we think that it's struck a good balance by the platforms themselves about dealing with content or behaviours online that cause harm.
Yeah, and I think I probably share your concerns about the transparency issue. One of the issues we explored with Twitter yesterday is that it has paused its transparency measures in two respects. One, they're not making available the reports on transparency actions that they've taken on their platform, and two, they've ceased the practice of labelling foreign state affiliated media accounts on their platform, which I think leaves users in a much more difficult position to identify the sources of information. Again, they seem like worthwhile avenues for exploring, including possible legislation or mandates to require transparency measures from platforms in a way that doesn't run the same risk of excessive or preemptive censorship of Australians' rights to free speech.
Senator, I think what the bill does try to tease out is those areas where, and I'll leave to the department to go into the definitions, where it's identified that serious harm can occur, and that may be beyond foreign interference.
Yes, I
and
agree.
Still be serious harm.
I acknowledge
so
that.
that's what the current code is trying to grapple with, and that is what the bill is trying to put some framework around that as a backstop, and also important information gathering powers for us to make things more transparent.
Yeah, and this committee is only concerned with the foreign interference angle of it, which is why my questions are focused on that. I might share the call